Greetings, everyone. Welcome to our event today. I have a feeling we'll have a few more trickling in. I'm grateful for everyone who's here today. I will say, we've hosted, the Bech-Loughlin First Amendment Center has hosted a lot of events this year, but they've all been at other parts on campus or in other parts of the law school. This is our first one that we're actually hosting in what is also now the Bech-Loughlin 1L Suite, if you haven't noticed that. So for those of you who are law students, the donors that helped endow the Bech-Loughlin First Amendment Center have now also chipped in money to renovate the entire 1L wing of the law school, and so we're very thankful to them and grateful for their continued contributions to Texas law. I am very, very pleased today to have Judge Ryan Nelson with us as part of the First Amendment Center's Judicial Perspectives on the First Amendment series that we try to do every year. So thank you, Judge, for coming. Most of you will not know this, but I will out the judge and his wife. They were just in meetings with the Ninth Circuit in Hawaii, got on a red eye and flew here, and then basically came straight to this meeting. So he's giving this talk on no sleep, and we're thankful for the sacrifice to be here with us. I will introduce the judge, get out of the way, and after he gives his remarks, we'll open it up to questions, and please feel free to aggressively ask him questions. If you've got a doubt in your mind or questions there percolating, please ask away. So Judge Ryan Nelson was confirmed to the U.S. Court of Appeals for the Ninth Circuit in October 2018. Prior to his appointment to the bench, he served as General Counsel of Melaleuca, Inc. He previously served as Special Counsel to the ranking member of the Senate Judiciary Committee, as a law clerk to the Senate Legal Counsel, as Deputy General Counsel to the White House Office of Management and Budget, and as Deputy Assistant Attorney General in the Environment and Natural Resources Division of the U.S. Department of Justice. Earlier in his career, Judge Nelson was an associate in the Washington, D.C. office of Sidley Austin. Judge Nelson received his B.A. from Brigham Young University and his J.D. from BYU Law School, graduating with honors and inducted into the Order of the Coit. Now is the moment where Texas fans throw things at him because BYU and Texas are playing tomorrow, so go ahead. He clerked for Judge Karen LaCraft Henderson of the U.S. Court of Appeals for the District of Columbia Circuit and for Judges Charles N. Brower and Richard M. Mosk of the Iran-U.S. Claims Tribunal at The Hague. That, of course, is a abbreviated biography of a very accomplished attorney, but we're very thankful for him coming today, so please help me welcome Judge Nelson.
I am very glad to be here. This is my first opportunity to come to Texas, and we've already received a very warm welcome and grateful to have the opportunity. I hired my first Texas law clerk, so we're gonna get you guys away from the Fifth Circuit and onto the Ninth Circuit. So please keep open mind towards that as you listen to this today and look at your future careers. I wanted to talk today about the current role of history and tradition in constitutional interpretation. I want to discuss the United States Supreme Court's growing reliance on a historical analysis and how such methodology functions and how it might interact with certain of the First Amendment constitutional provisions in the Bill of Rights. History and tradition play an increasingly key role in how the currently constituted Supreme Court resolves its most important constitutional questions. Consider some cases that have grabbed the biggest headlines or impacted the greatest number of people. In Moore versus Harper from last term, the court rejected a form of the so-called independent state legislature doctrine. The court held that the Constitution's election clause does not vest exclusive power in state legislatures to create rules for federal elections. Rather, the court affirmed state courts' power to perform judicial review of the acts of legislatures. And to reach that conclusion, the court looked especially to history, noting that early state cases, debates at the Constitutional Convention, and writings defending the Constitution all advanced the concept of judicial review. Then, in the years immediately following ratification, multiple state courts voided laws incompatible with constitutional provisions. Thus, even before, and certainly by the time that Marbury versus Madison was decided in 1803, courts' power to review legislative action was long and well established in the American tradition. 2 terms ago, the court decided Dobbs versus Jackson Women's Health Organization, and there, as you know, the Supreme Court reversed Roe versus Wade and Planned Parenthood versus Casey, and held that the federal Constitution does not provide a right to abortion. The majority concluded that the right was not deeply rooted in the nation's history and tradition. To the contrary, the nation's history reflected an unbroken tradition of prohibiting abortion on pain of criminal punishment, persisting from the earliest days of the common law until 1973. That same term in Kennedy versus Bremerton School District, a case that I was involved in, the Supreme Court reversed my court and held that the Establishment Clause did not prohibit a high school football coach from praying on the field after the game in his private capacity. The court made clear that the Establishment Clause must be interpreted by reference to historical practices and understandings. In the process, the court rejected the district court's reasoning that any visible religious expression by a teacher or coach would be unconstitutionally coercive. And that was rejected because it was not founded on any historically sound understanding and would undermine the long constitutional tradition of tolerating diverse expressive activities. And finally, in New York State Rifle and Pistol Association versus Bruen, the court held that New York's handgun licensing regime violated the Second Amendment. The court rejected claims that laws restricting the right to bear arms were subject to a means-ends balancing. Instead, the court imposed a test rooted in the Second Amendment's text as informed by history. Under that test, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. New York's law failed under this analysis. We should not be afraid of history and tradition. The judiciary has, of course, always looked to history in deciding its cases, but the Supreme Court has recently underscored history and tradition, departing from the court's practice of the last few decades. You are the first generation of law students to start your careers in this new era. And some express concern about the administrability of a framework based on history and tradition. After all, lawyers are not trained in history. For example, Judge Carlton Reeves on the Southern District of Mississippi offered a criticism of the Bruen framework. He said, "This court is not a trained historian. The justices of the Supreme Court, distinguished as they may be, are not trained historians. We lack both the methodological and substantive knowledge that historians possess. The sifting of evidence that judges perform is different than the sifting of sources and methodologies that historians perform." I, however, have a different perspective. In my view, judges trained in the law are better equipped to identify whether a law follows our nation's established legal history and tradition than to analyze policy or a law's cost and benefits, or to serve as philosopher kings imposing our view of the good on society. As Professor Will Bott noted, history is inextricably connected to law. Our Constitution and statutes were enacted in the past and amended in the past, and so understanding their content is an inherently historical endeavor. History, practiced properly, also can supply objectivity, giving the justices a basis for deciding beyond their personal views and the controversies of the day. Moreover, the nature of the inquiry is different for judges than it is for historians. Unlike historians, judges do not resolve historical questions in the abstract, as Justice Thomas said in Bruen. We resolve cases and controversies in an adversarial system. There are principles of party presentation that allow the court to decide a case based on the historical record compiled by the parties and burdens of proof and persuasion that control when the evidence compiled leaves us with uncertainty. This is not too different from how we resolve complicated environmental or antitrust cases despite our lack of training in environmental science or economics. To illustrate the judiciary's ability to do this sort of work, I'd like to discuss a Second Amendment opinion I wrote just before Bruen was issued, Jones versus Bonta. Though we vacated the opinion and remanded to the district court in light of Bruen, my opinion in Jones shows the sort of historical analysis that might become more frequent in light of Bruen. Jones involved the Second Amendment challenge to California's restrictions on the sale of long guns and semi-automatic centerfire rifles to anyone under the age of 21. The district court ruled that these restrictions did not burden Second Amendment rights at all because individuals under 21 were considered minors for most of our country's history without the rights that are afforded to adults. We reversed, the panel reversed, the majority of the panel reversed, explaining that the district court's analysis was plainly incorrect in light of the objective historical record. Going back many centuries, able-bodied Englishmen, at least 15 years old, were compelled to possess personal arms and had to take part in the militia and other institutions that required them to keep and bear personal arms. American colonists brought this tradition to our shores, and colonial militias almost always included young men ages 18 or even younger. At the time of the founding, all states required young adults to serve in the militia, and all states required young adults to acquire and possess their own firearms. Just after the Second Amendment was ratified, Congress established a federal militia, including young adults, and required them to acquire and possess their own weapons. All in all, the historical record was clear that young adults were expected to bear arms at the time of the founding, and therefore must have been among those viewed as holding Second Amendment rights. California offered evidence that there were Reconstruction-era restrictions on minors' access to firearms. But almost all of those laws governed handguns, not rifles, which was at issue in our case, and only 5 of those states had laws completely banning the sale of firearms to minors. Of those 5 states, 3 had no Second Amendment analog in their state constitutions. We concluded that the remaining 2 states were outliers and could not overcome the centuries-long tradition of protecting young adults' right to bear arms. Relying on this historical analysis, the majority of the panel concluded that California's law was too restrictive under the Second Amendment and that the plaintiffs were likely to prevail on the merits. I would note as an aside, we upheld a separate provision that required a training program because we looked at what the historical analysis was there, where not only were young adults expected to own and possess their firearms, but they were required to muster and show that they knew how to use them. And so based on that historical record, we did not enjoin that portion of the law. Or I should say we upheld the district court's decision on that portion of the law. So even though history and tradition allows for a more objective inquiry, this methodological lens remains under development. Here are a few of the many open questions about how to apply history when construing the constitutional text. First, how instructive is early practice in divining the Constitution's meaning? Justice Barrett noted in her Bruen concurrence that there is an ongoing debate about what periods of history are relevant to the analysis. For example, how long after ratification may subsequent practices be considered? The acts of the first Congress are likely to be probative. But how many years out can you go before subsequent legislation becomes less reflective of the provision's original public meaning? Likewise, for amendments that have been incorporated against the states, is the relevant period when the 14th Amendment was ratified in 1868 or when the Bill of Rights was ratified in 1791. Second, and relatedly, the history of incorporation adds some interesting wrinkles to a history and tradition analysis. The Bill of Rights only limited the federal government when it was adopted. It applies to the states through the 14th Amendment, which was not ratified until 1868. But even then, it was not until 1925 in Gitlow versus New York that courts began to recognize that the 14th Amendment caused provisions of the Bill of Rights to apply to states. Indeed, it was not all that long ago that the Second Amendment was incorporated against states in McDonald versus City of Chicago. More recently still, excessive fines clauses were incorporated, and I'm still waiting for a case asking for the incorporation of the Third Amendment's prohibition on the quartering of soldiers. We haven't seen that yet. But Bruen instructs that if the text covers an individual's conduct, the government must show the law consistent with this nation's historical tradition of regulation. This is an interesting inquiry, however, because much, if not most, government regulation occurs at the state and local level, a context to which the Bill of Rights did not apply for much of this nation's history. So how do we construe our Bill of Rights in light of the nation's history and tradition when the Bill of Rights did not constrain most laws in our nation's history and tradition? Part of that answer lies with state law and state constitutions. Our founders wisely created a federal system where liberty could be protected at both the federal and state governments. And throughout history, many rights protected by the federal Constitution were protected at the state level as well. For example, 4 states adopted clear analogs to the federal Second Amendment in the period between independence and the ratification of the Bill of Rights. And between 1789 and 1820, 9 states adopted Second Amendment analogs. So even if the federal Second Amendment did not apply to the states, long-standing sister provisions in state constitutions give us a robust historical record to evaluate when considering whether a current law is contrary to our nation's history and traditions of regulation. But what are we to do if the Second Amendment analogs in those states were not truly analogous? What if they expressly protected only a collective rather than an individual right? Leaving those questions aside, evaluating other provisions of the Federal Bill of Rights is more complicated still, because not all rights had state analogs. Take the Establishment Clause. It provides that Congress shall make no law respecting an establishment of religion. But unlike the Second Amendment, many states lack similar provisions because they wanted an established church. 9 of the 13 colonies had established churches at the time of the founding, and about half of the states continued to have some form of official establishment when the First Amendment was adopted. This creates an interesting puzzle when conducting a history and tradition analysis, because as a matter of history, the Federal Bill of Rights served as a protection for state-established churches by preventing the newly formed federal government from establishing religion or from interfering in the religious establishments of the states. Nor can we easily draw from English common law history to understand the meaning of the Establishment Clause like we can for the right to bear arms, as the Church of England was the established church of the mother country at the founding, and it had been for centuries. Even so, history has much to teach us about the Establishment Clause. As Professor Michael McConnell notes, we can discern the hallmarks of a religious establishment by comparing states that had an established church to those that did not. We can also look to the process of disestablishment by which the states ended their established churches and note what formal changes occurred. Drawing on this analysis, Justice Gorsuch noted that founding-era religious establishments bore some telling traits that should be in our analysis today. Government control of church doctrine and personnel, mandated church attendance, punishment of dissenting views, financial support for one church over another, and use of the church to conduct certain civil functions in a way that gave the church a monopoly control over certain governmental functions. Finally, I'd like to offer some thoughts about the impact that this shift to history and tradition may have in different contexts within the First Amendment. To start, I suspect that the shift will lead to decreased judicial discretion. At least I hope that's true. A recent case in the Ninth Circuit, which I probably shouldn't comment on because it's still pending, leads me to question whether this is true, but this is my great hope. To start, I suspect that the shift will limit this discretion of judges. If anything, I suspect that this was by design. Note that the three areas where the Supreme Court strongly invoked history and tradition in recent years, the Establishment Clause in Kennedy, gun rights in Bruen, and substantive due process rights in Dobbs. All three of these cases arise in contexts where the law was a mess of judge-empowering doctrines and manipulable tests by which judges could reach any preferred outcome that they wanted. Establishment Clause jurisprudence over the last 40 years has been plagued by inconsistency and manipulability. Several courts and commentators, myself included, have noted that the Lemon Test, which asked whether the purpose and effect of a challenged government action were religious, left courts able to reach almost any result in any case, and so strikingly similar facts resulted in contradictory outcomes. Likewise, before Bruen, the gun laws often faced an intermediate scrutiny test that asked whether there was a reasonable fit between the law and important or substantial government goal. But reasonableness and importance are often in the eye of the beholder, and accordingly, the Second Amendment was often treated as a second-class right. My own court, the Ninth Circuit, heard dozens of gun cases and did not strike down any state or federal law under the Second Amendment. Similarly, in Dobbs, the Supreme Court emphasized that its decision was guided by history and tradition, while past substantive due process cases had not shown respect for the teachings of history and reflected free-willing judicial policymaking. All in all, it seems that the court is most likely to turn to history and tradition, where the current doctrine vests judges with too much power and discretion and has spun out of control. Now let's turn to the Establishment Clause. In my view, the focus on history and tradition in cases involving the Establishment Clause will be an important and beneficial change. An Establishment Clause rooted in history and original understanding will check the modern inclination to banish religion from public life. For example, in Kennedy, the football coach was disciplined because his personal religious conduct was done in the public view. Yet the historical record shows that allowing religion in the public square was never understood to be a religious establishment. Quite the opposite, our history is replete with instances of the various branches of the federal government acknowledging the important role of religion in American life. George Washington's first official act as president gave fervent supplications to that almighty being who rules over the universe. Just days after the Establishment Clause was ratified, Congress passed legislation providing for paid chaplains for the House and Senate. Overtly religious practices in public settings did not violate the Establishment Clause when it was adopted, and they likewise do not do so now. History and tradition thus informs Kennedy's free exercise rights as compared to the school district's Establishment Clause interests. Next, let's discuss the Free Exercise Clause, because that appears to be a context where the court is particularly wrestling with how to apply history. Originalists and proponents of religious liberty have long criticized the current free exercise test articulated in Employment Division versus Smith. That case applies a rational basis standard when reviewing neutral and generally applicable laws, even when they burden religion. A higher level of scrutiny is only available in rare cases, such as when the government targets religious conduct. The case seemed ripe for reversal in 2021 in Fulton versus City of Philadelphia, which considered a free exercise challenge by a Catholic foster agency, which was denied a contract because it would not comply with the city's non-discrimination policy. but the majority opinion by Chief Justice Roberts resolved the case on narrow grounds, holding that the city policy was not generally applicable because it included a system that allowed individualized exceptions at the discretion of the government. On those facts, the facts of the case triggered strict scrutiny. 3 justices, Justice Thomas, Alito, and Gorsuch, concurred only in the judgment. Justice Alito wrote a 70-page concurrence calling for the overruling of Smith outright. Justice Alito relied heavily on history, looking to early colonial charters, state constitutional analogs, and early federal action, and concluding that the dominant practice was to provide broad protection for the free exercise of religion, except where public peace or safety would be endangered, whether or not the law was generally applicable. Justice Barrett, however, wrote a concurrence and explained that she struggled with what should replace Smith, noting that the prevailing assumption seems to be that strict scrutiny would apply whenever a neutral and generally applicable law burdens religious exercise. In her view, the historical record was more silent than supportive for this proposition, and thus the court needn't take up the question when the case could be resolved on narrower grounds under existing doctrine. This divergence shows how the historical record may be read in different ways, even among judges of similar methodological stripes. Finally, I want to address the free speech clause because this may present an area where history and tradition may be in special tension with existing doctrine. We currently enjoy extremely robust protections of free expression. From Nazis marching in Skokie, to pornography, to campaign expenditures, to protests at soldiers' funerals, to cheerleaders posting expletives on Snapchat, current free speech doctrine protects all manner of conduct and communications. In some sense, history already is key to free speech law. The court has described certain types of expressive conduct as falling within historic and traditional categories, lacking constitutional protection. Those include obscenity, defamation, fraud, incitement, and speech integral to criminal conduct. If the speech falls within one of those long recognized categories, there is no constitutional problem in the government preventing or punishing it. But history and tradition are not the absolute guides for the court's free speech precedents. Many scholars have noted that modern speech doctrine, which emerged in the 20th century, bears almost no resemblance to 18th century judicial decisions. There is reason to think the historical right was more limited than what we enjoy today. After all, the same generation that wrote the First Amendment also wrote the Alien and Sedition Act of 1798. There are strong arguments on both sides, so I reserve judgment on this question, especially when the issue may very well come up before our court. But it is at least possible that a sharp return to a historically delineated right might result in less free speech protection than what we have currently come to expect. If the court emphasized history and tradition to a greater degree in the speech context, there may also be a need to alter the current analytical framework. As you have learned, or will learn, if you're one else in constitutional law, much of free speech case law uses the tiers of scrutiny, applying strict or intermediate scrutiny depending on the type of speech and the severity of the burden. But that is the precise sort of means-end analysis that Bruen rejected in favor of a history and tradition-based approach. As Judge Newsom of the 11th Circuit noted, and many of my colleagues from around the country have made similar comments, such balancing tests are judge-empowering and freedom-diluting, and it is bizarre to decry balancing tests in the Second Amendment while regularly applying them for other fundamental rights. Only time will tell how the Supreme Court will handle these tensions. It might rely on stare decisis and allow the free speech clause to be on its own track, notwithstanding the inconsistency or potential inconsistency with how other fundamental rights are treated. or the court might continue its project of aligning its doctrine across the board with history and tradition. For now, especially on the Ninth Circuit, we faithfully apply the court's cases. Thank you very much for taking the time with me as I walk through these cases and the court's history and tradition analysis and how it may apply to different constitutional protections going forward. I welcome your questions on history and tradition, First Amendment, or quite frankly, anything else, including the BYU Texas game. I'm not going to go for BYU as much as I want to. I'm not going to say that we're going to win, so, especially not in this house. We'll start at the top. Yeah. She was just barely beat you. Then we'll go. I take it there's a little rivalry here. Yes, like all right. Well, you won today.
I have a question with perspective on the difference, if you see one, between history and tradition in the text history tradition analysis. So I've heard some commentators say that in application it seems like there's really no distinction between the two. It's kind of like a linguistic flourish, using both words. And I've heard other commentators say that tradition is kind of irrelevant for understanding original public meaning because it's post-enactment ratification period. So I'm curious to your thoughts on that.
It's a very good question. It is. I probably should list that as like one. I mean, there's a whole bunch of questions that are coming out of this, and that is a key question: is there a difference between history and tradition? And actually, if you go and look at the different tests that are in Bruen and Kennedy, they're framed differently. And I don't know if that's by design or because different authors, are using it. But my sense is that different justices have a different view of really what's meant here. And that's going to be very interesting as we get some of these cases up. I mean, right now, I think they've sort of set the benchmark, and then, we'll let the lower courts percolate and kind of work through some of these issues. But I think we're going to start to see, some of the differences between history and tradition, because I think there are some differences, and one is, as you pointed out, that history seems to be more aligned with, or potentially more aligned, I should say, with the original public meaning, whereas tradition is sort of what comes out of that. But I guess the comment from my speech that I think touches on that is it goes to, and this is where tradition comes in, is how far out do you go before tradition is not really relevant? And I mean, this is going to become a big issue in the Second Amendment because, we're dealing with a lot of cases on the Ninth Circuit right now, large capacity magazines and so forth, where the regulations weren't coming in until fairly recently. And the arguments on one side is, well, that doesn't make any sense because you're saying that a new technology can't be regulated just because there's no prior history and tradition of outlining something that didn't come up. I think it's different than that. We've got to be smarter as judges on applying this history and tradition and coming up with analogies. One of the district court judges right after Bruen said, well, there's a challenge to the law that says it's illegal to cross out serial numbers on a gun. And because there were no serial numbers on a gun back, at the time of the founding, that's clearly an unconstitutional law. That, in my opinion, is lazy application of what the Supreme Court is saying. And we've got to get beyond that and start thinking about this. This isn't new. The Fourth Amendment, I mean, we had, infrared, abilities to search out things that no one would have ever thought of. I mean, I guarantee you, AI and other things are going to present issues in the Fourth Amendment context that we couldn't even fathom today. And 10 years from now, we'll be learning about it. We don't just say, oh, we don't know how to deal with this. We apply the principles that have passed down to us through our history tradition, and we apply them to new technologies. So, but that is going to be one of the issues that needs to be fleshed out, is kind of where those differences, and sometimes it's not going to be an impactful difference. In other cases, I could see making a a substantial impact. All right, we'll go below, yeah.
Okay. So there's been a recent rise in scholarship in the field of corpus linguistics.
Yeah.
And I'd love to know how that would fit into an analysis of history and traditions, whether it has a place in applying the law in that sense.
So I'm a big fan of corpus linguistics, and I've tried to use it. It turns out it's hard to use in a lot of opinions. I've done a lot of research on various issues, and a lot of it's been left on the floor because it just doesn't, it doesn't warrant getting into an opinion. But actually, my dissent from denial rehearing in Kennedy, I cited corpus linguistics for looking, and it was an article by Stephanie Barclay where she'd actually done the work. I mean, the reality is it's hard. This history and tradition stuff for judges I'm sympathetic to the district court judges because it's hard even as appellate judges to do this stuff. The same is true of corpus linguistics. I mean, I think they're very distinct in the analytical framework, but I do think that that it's helpful. I guess I would view them both as different avenues to try and get at what the original public meaning of the term actually was. And anything that pushes us to that, in my view, is a good thing. Because, like I mentioned, I think the less discretion the judges have, the better. Nobody elected me, and if somebody doesn't like my opinion, they can't unelect me. I mean, so I have to, I should be bound and constrained by something more than legislators, the other two branches of government. If they can act and they can get voted out of office. I think they have a lot more leeway in how they act. But I think for judges, we've got to have something that tethers us to the Constitution and makes it more of an objective analysis. Corpus linguistics, in my view, is one of those, and it'll get better over time. So, yeah.
So you've talked a couple of times about history and tradition being a lens that provides more objectivity, and even if that is the case, I'm curious how you would respond to the idea that history itself is not objective, and that even if we're looking at a body of history and applying it objectively, the content of that history, for example, in the religion context, favors Christianity, just because the majority of the country for so much of its history has been Christian, and I'm curious how you would think about potential subjectivities coming in through the body of history itself.
Yeah, look, it's a good question. I would push back a little bit on I mean, yes, we were a Christian country to start with, but George Washington, in the very beginning, went to the Jewish synagogues and some of the other religions and said, look, the First Amendment protects you in the same way that it protects every other church. And so I think even from the very beginning, there was an understanding that, discrimination or application of these standards among the different sects, religious sects, was not compatible with the First Amendment, at least as it applied to the federal government. I mean, what you may be referencing, perhaps, is some of the, I mean, as I mentioned, there's state-established religions, and that was a whole different ballgame. And that's where the free exercise and the establishment clause get a little dicey. I don't think that the Supreme Court's going to come back and say, oh, state-established churches are now constitutional, because they were historically. I don't think we're going to go that far. Maybe I'm wrong, but I just think that ship has sailed, So, so I think there are going to be some limits on what history and tradition can do, even if you look at the record. And if we look at the record and say this is wrong. Another example, Second Amendment law. A lot of the restrictions that are supported in the Second Amendment law are based on the Reconstruction era Southern states. Well, the problem with that is, why were the Southern states adopting these restrictions on gun ownership? It was to keep guns out of the hands of slaves. I think we would be loath to start looking at that history and tradition and say, okay, we're going to apply that as a reasonable analogy, because it doesn't strike at the heart of what America was at the time of the founding and aims to become. So we're going to refine this. We're going to certainly refine this test over the coming decades. But I think it's a good starting point, and we'll have to figure out what some of those limits are. Yeah.
One of the goals of the History and Tradition project is to constrain judges and make the project more objective. It seems like the area of historical analogs, you can get more discretion. Is there any ways to approach finding proper historical analogs that is more objective, that is more constraining to judges, that doesn't just let judges either be lazy one way or be lazy another way?
We'll find out. So I'm on the Duncan case in the Ninth Circuit, and I won't comment on it because we're still pending. We've got it before an en banc court, 11 judges. You can go read some dissents that we recently wrote on this. But the one telling thing, and I joined the dissent on whether to grant a stay of this, was that after Bruen on high capacity magazines, you still had, I can't remember the exact stat, but it's like 8 out of 10 district courts had upheld the regulation. And I don't think I'm giving away the farm by saying I disagree with that analysis, because I'm not going to go any further than the dissent that I joined on that. But that's what gives me some pause, that this hope that this is going to, rearranging the deck chairs and the analysis is going to bring back as much objectivity as we hoped it would, and as Justice Thomas hoped it would. Look, Justice Thomas spent a decade writing Bruen before that case ever came up, right? I mean, he thought through every avenue, and some judges are quite frankly not happy about it. And I will say, some commentators, including perceived to be kind of conservative commentators, don't actually agree that the analysis flows logically. So there's been a lot of criticism all around. The one thing I would say is, I think it was driven a lot by the fact that there was increasing frustration on the Supreme Court that the lower courts just weren't taking the Second Amendment seriously. And whether they found a way to, and there's some issues that are just very difficult. Abortion, guns, on the Ninth Circuit, sometimes immigration. They become very difficult to sort of truly take as objective of an analysis as we would want to. But I have faith in America. I have faith in the Republic, and I think over the long haul, we're going to get this right. And we're gonna, but that's part of the debate. I mean, the founders weren't unified as well on what they thought things meant. So it's not surprising that we have some differences of opinion. And as I noted, you go to the free exercise context with Smith, there's differences of opinion even among those who might be otherwise, judicially aligned. So. Other questions? Yeah.
When there is ambiguity, why stick with history and tradition? Why not move to other forms of argument? Like you mentioned the free exercise clause or the Second Amendment. At what point do you just say there's enough ambiguity that history and tradition isn't going to give us an answer, so we should go to doctrine or another form of argument?
Well, I guess that's really a question for the Supreme Court now, because I think they've sort of said, no, we're going to go to history and tradition. And Bruen addresses that question, because what Bruen does is Bruen sets the burden with the government to say the government has to show that this has been regulated historically, and if they can't, then you can't regulate. So why did we do that? I mean, I think that goes a little bit back to my prior answer, was I think there was just a great fear that that the lower courts weren't taking the Second Amendment as seriously as it needed to be taken, and so the burden analysis was going to be realigned, and Justice Thomas did just that in Bruen. As to the other cases, it's a good question. I don't know. Because Kennedy, I guess, doesn't really say like, this is it, although it almost implicitly does. I mean, by rejecting Lemon, I think it almost implicitly says we're not going to look to some of these other methodologies anymore. Look, as a practitioner, I was at the Department of Justice, and some of you, if anybody here from California and La Jolla, or no, you're all Texans, no California. But there's a big cross that's been there since 1913, the Mount Soledad Cross in San Diego in La Jolla, and we were litigating that at the Department of Justice, saying it was constitutional, and it was very frustrating as a litigant because we had to basically write 2 briefs because it wasn't even clear whether the Lemon test was going to be applied or whether the Van Orden test was going to be applied, which was sort of peeking back into this history and tradition in the Establishment Clause context. So we basically had to, write 2 briefs and say, look, if you apply Lemon, here's why we win. If you apply Van Orden, here's why we win. So, I mean, I hope that the Supreme Court, I think what they've been trying to do is clarify this issue, that this is the test now, and, we're stuck with it. And we're going to have to work through these things about, well, how much is too much? I dealt with this issue in Jones. We have 2 states that clearly regulated all firearms, the sale of all firearms, including rifles. Is that enough? What do we do with it? 2 didn't seem like enough. But what if it was evenly split and it was 13 states on each side of the equation? Those are questions we're going to have to grapple with as they come up, and we'll see how it nets out. So. Other questions? Yeah.
So, how do judges who are applying this history and tradition test determine what the upper and lower bounds of it are? And by that I mean, what's the starting point? How far are we going back? And then, at what point is something considered to be, okay, this is no longer considered history? Like, where's that? How do you determine that timeline?
Well, as I mentioned in the speech, I mean, I think this is one of the bigger debates that the courts are going to have to grapple with. I think it is clear, and the Supreme Court has sort of waffled on this a little bit back and forth. I think it is clear that anything from the founding era is, sort of gold, if you will, right? And then, you get to silver, and you get to copper, and you get to bronze. It's not entirely clear, where those delineations are. But I think the next period that is highly probative is after the 14th Amendment was adopted. But even then, you have to grapple with some difficult analytical, questions. So it's not entirely clear. And some Supreme Court justices have said we shouldn't be looking to that at all. Others have said, I think Justice Scalia said, yes, it's relevant, but it can't override what was done at the time of the founding. So I think we're going to have to address that. And litigants are going to have to get versed in this. I mean, the one thing I will say is that the courts, including my court, we're going to be heavily reliant on litigants coming in. It's very difficult to do this research on your own. I've done it, and Jones versus Bonta was a very difficult opinion to write. Very fun, but it required an enormous amount of work. The one thing I'll say is, I'll make a pitch. We got some law professors here. This area, and for any of you who are going into, thinking about going into academics, this is prime for academic research, because I think there's got to be some give and take with the judiciary and the academy on these issues, because the academy has time, and this is up their bailiwick, to kind of delve in and analyze this. And obviously we can't just take that verbatim as judges, but boy, being able to go to an article and get some original sources that are, is hugely beneficial on how we do this. And I think we'll start to build this up. I mean, there's already some of this at the Supreme Court. We're getting an understanding of how the Second Amendment worked historically. I think the piece parts are there, but as students, think about how you can incorporate history and tradition. Think about that in your cases when you're taking constitutional law. Think about the historical trends that are coming out. It's a good thing to cite an 1800s Supreme Court case. Some people think that's not very valid, but I love it when a litigant comes in and thoughtfully cites that for, hey, let's take a step back and look at where the doctrine is. So you should be thinking about things you can do to incorporate that into some of your studies and some of your legal training as you get out into the real world. Because, like I say, it's going to become more of an impact for your generation of lawyers than it has been in the past, I think. Yeah.
Building off of that, we're fortunate at Texas to have at least one class that I know of on the origins of the federal Constitution. What do law schools need to be doing to better prepare their students for these sorts of arguments and this new approach?
Yeah, I think getting I have the great privilege of teaching a class on Federalist and Anti-Federalist papers at BYU, and I teach it at Berkeley as well. And I love that opportunity. I'm going to start expanding it a little bit into more some of the more additional documents and founding area materials. And I think schools would benefit from offering that. And I don't know the whole history on why that, how much that's offered or across the board. But I think it's helpful. I mean, if you haven't read the Federalist Papers, if you haven't read some of the founding documents in history before you get out of law school, whether it's for a class or just on your own, you need to do that. I mean, you really do. And not just because you might cite it in a, I try and cite the Federalist Papers, and it's actually kind of hard to cite, but the principles are important, and the principles inform the doctrine that comes out of our constitutional framework. And so I think going back to those origins is really important. And there's a lot of ways to do this. I mean, now, today, in the world, you're all familiar with, there's podcasts, there's some great podcasts that walk through this stuff. And delves back further. I was just at an originalism conference 2 weeks ago in San Diego, and we were talking about this very issue of how can judges deal with it. And Judge Kethledge on the Sixth Circuit spoke up, and he was a history. Talk about. I said to him afterwards, I'm like, you're primed for it. He was a history major undergrad, and he starts walking into, we can't stop there, we got to go back to the 900s, and starts talking about some king I'd never heard of, and how the jury came from him. He'd go around to the medieval areas and call all the people together, and 12 coalesced as a number for the jury at the time, and I was like, God bless you. I don't know that stuff, but the point is, there is a lot that we can learn, and the deeper we delve into this stuff, the more beneficial we're going to be in thinking. If we understand our history, we understand, what our future needs to be, and that history is very important. Those traditions are very important, and we need to thoughtfully address how that applies to our current thinking today. So, yeah.
You mentioned in response to another question that periods of history are like gold, silver, copper, bronze, whatever. I'm curious, as technology continues to develop, is there room in a definition of history to consider, when we're talking about AI, for example, can history then become history since we created computers? Is there room for that kind of analysis?
I think it depends on the context. I think the history and tradition that we're talking about is understanding the principles that govern the constitutional framework. So it depends on what, if that comes up in a Fourth Amendment context like I was talking about. I think the history and tradition of the Fourth Amendment is what really matters, going back to the founding. Having said that, I do think that, if we haven't taken action, if technology's been around for 20 or 30 or 40 years, the internet is a good example right now. you know, there's been this long-standing tradition, if you will, that it's going to be the Wild West out there. Now, Congress stepped in, you know, and passed immunities and Section 230 and things like that, that sort of codifies some of that tradition. So now we're looking at a statutory basis for that. But still, you know, that tradition in history, I think, is going to roll into this as we go forward. So I guess I'm sort of giving both answers. I mean, number one, you know, we should be looking at the doctrinal history. But number two, there's no question that as technologies come up, we'll look at how those are being applied and used. I think we may have time for one or maybe two more questions. I saw a hand up. Maybe one more. Yeah, one more.
Thank you. This has been great. I hope I'm not being a head horse here, but Bruen's obviously so interesting. There's a lot of questions. I know the Supreme Court will have a chance to revisit it in Rahimi, and I'm curious if you can provide any comments on how you think that might come out, especially considering that the facts are very different from Bruen, maybe a little more sensational given that it deals with domestic violence. So I'm curious how, especially the facts might impact the Bruen.
I'm very interested to see what happens in the case. I can tell you that because, and I'm also, I think there's another Second Amendment case coming up over there. Maybe I'm wrong about that. I thought, but the bottom line is I'm gratified that the Supreme Court is actually taking more of these cases because we do need some direction. I don't think it's fair to just say, hey, every 10 or 15 years we're going to step in and give you some, you know, guidance from on high. I mean, there's a ton of these questions that need to be addressed. And so in answer to your question, I don't know how, I really don't know how that's going to come out. I don't know, but I am watching it like the rest of you because I think it is going to inform better and just flesh out better how this test applies and how litigants and lower courts should be applying it. So sorry if that's not as neat. So, all right. Thanks. Thanks. Yeah.
Our next event is going to be, I think it's our next event, is November 9th in the Eitman Courtroom, and it's the book launch on a book on free speech by Nadine Strawson, who's the former national president of the ACLU. She and Steve Vladeck and Greg Salmiari from the Salem Center will be discussing that. I encourage you to comment on the theme of the football weekend. Would all of you please join me in welcoming the Dean of BYU Law here today. The tomatoes that you can throw out at him are in bags out there. Thank you all for coming.